People versus Shader.
May it please the court, Jill Sanders for appellant Timothy Shader. Could I please reserve 3 minutes for rebuttal?
Yes.
Thank you. In this 16802 petition, Mr. Shader proved by clear and convincing evidence that he was a level 1, low risk of reoffense. Yet despite all of that evidence, he remains on the registry as a level 2. The board significantly did not oppose a level 1 modification.
What's the error here that we could find? I mean, there's a certain amount of discretion the judge has in weighing the evidence and making a determination whether you proved this, and specifically whether you proved a reduction was warranted from 3 to a 1 as opposed to what the judge did, which is 3 to a 2. So how do we, what's the error here?
So under the abuse of discretion standard, which applies here, there's 3 things on which the lower court relied and also the third department relied in upholding the trial court's decision, which was the nature of the instant offense, the prior instances which occurred prior to the offense, and the 2003 misdemeanor offense. The prior instances of sexual misconduct which occurred before 1977 were completely accounted for in the risk assessment instrument.
Which gave him a level 3.
Which gave him level 3 at the 1998 SORA hearing.
Right.
The nature of the instant offense was also accounted for in the risk assessment
Right.
instrument. So those 2 factors were completely accounted for in arriving at the original level 3.
A level 3, and now your burden is, by clear and convincing evidence, to show why you have to come off of a level 3.
Correct. And he proved with various different factors that he had done everything he could.
Right, but the judge didn't find that was enough, so what's the error of law?
What else could he do? That essentially is what it is. The only things that were found to have been the flaws that were held against Mr. Shader.
It seems to me that the judge here considered a number of things. The prior offenses, the offenses that led to the designation, some conduct that happened before, time that these things happened. That seems a perfectly fine framework. And are you saying that because it was such a long time, like from that as a matter of law made it an error the way he weighed those or she weighed those factors?
Yes, it is an abuse of discretion, because if we look at the Davis case, which was cited pretty heavily by myself and my colleague here, that it cannot be the tipping point in denying modification.
What can't be the tipping
The
point?
nature of the instant offense and
Well,
the
let's
things
say
that
I
were
brought,
relied
you
on.
brought this petition 2 years after. Why couldn't the nature of the offense be the tipping point then?
At that point, you mean 2 years after his original
say
SORA
it's
hearing?
2000.
Okay. At that point, that was only 2 years afterwards.
So when's the tipping point? 10 years?
In this case, we have.
But we need a rule, so what would we tell judges the tipping point is?
I think when you look on balance of the number of factors that were presented in Mr. Shader's favor,
Balance kind of sounds to me like discretion.
it is discretion, and here it was an abuse of discretion to find that the only things that counted against Mr.
And is
Shader.
it abuse of discretion simply because a decision in the opposite direction could have been made? Is that what you're arguing?
Because of the fact that there is, I think, and also the fact that.
Let's say there's equal evidence that would have supported the level 1, but the judge found there was equal that would support a 2, so he gave him a 2. That causes it to be an abuse of discretion? Is that what you're arguing?
It's an abuse of discretion because we are just essentially looking at Mr. Shader's criminal history and saying he can never be a level 1.
So you can't look at it? The court is forbidden for considering his prior criminal history. Is that what you're arguing?
No, and certainly not, and I don't think that's what Davis says, but it cannot be the tipping point to say that he can never be a level 1, particularly in light of the.
I don't understand this term, the tipping point. One, the judge looked at his material and said his recent evaluation, and that led to a reduction to level 2. So the judge was looking at everything that had been put in and said, this, you deserve a level 2. But it seems to me the balancing that goes on here is the nature of the offenses, including prior offenses, offense that led to the designation, subsequent offenses, which may or may not, and I know your argument here, these were minor, fine. And in looking at time that's gone by, seriousness of the conduct, what the defendant has put in to to push back against that, that's a decision that the judge then is weighing all those things. And I don't understand how we can say to a judge, you erred as a matter of law, you abused your discretion as a matter of law by looking at these, we would agree, quite serious crimes, and looking at the time that went by, looking at what happened after, looking at the material that was put in by the defendant, and saying, this isn't you're no longer a 3. I agree, you're a level 2. He's not saying you'll never be a level 1. As of this moment right now, what I see before me, you're right, you proved by clear and convincing evidence you're a 2, which is less onerous than a level 3 designation. Why, how could we say that on this record?
Because I think, to your point, is that there is no meaningful path to level 1
What
for
about
Mr.
5
Shader.
years from now, he comes in and says, now I should be a level 2, or
None of
2,
the-
or next year?
None of the factors which were relied upon in denying level 1 modification
Time
would
would
have
change.
changed.
Time would change.
And
Since you say that's a factor, how long between the offense and the designation and the determination of modification, time would change.
in the evidence that was put before the trial court was that statistically speaking, that he had already gotten to the point where he was no longer a risk of reoffense.
And the judge looked at the offenses and looked at the time that had passed and looked at what had happened after he was released and said, that's enough to get you to a level 2.
Here, where there is no path to level 1, which
Why is there no path? You didn't get a level 1.
Correct.
But I don't understand why that means you'll never get a level 1.
if there is a path to a level 1, then there is no statement in the law that says, well, then it has to be 40 years of,
No, and there's no statement it has to be 2 years. There's no statement at all. It's up to the judge to weigh these factors.
that is correct, Judge, but here where we're talking about somebody who the offense was, at the time, 45 years prior to the time of the petition, 20-some years, 1998 was the date of his release. He petitioned in 2022, having completed parole, having completed sex offense treatment, having attained educational, vocational training, having abided by his SORA registration requirements for all those years, having been in a long-term relationship. He's statistically less likely to reoffend, as was put in the papers, and having the forensic evaluation.
So how does the judge's discretion play into it?
Here, because there was nothing other than his criminal history to point towards the
But the
fact.
judge did have the right to exercise discretion in making its determination, right?
The judge
court.
does have discretion and always does.
But it seems to me you're saying on these facts, the judge had no discretion and was compelled to go down to 1, not just down to 2. Is that right?
Here, there was no evidence to overcome the fact that there was a
Okay.
recommendation.
So this judge had no choice, on your view, did not have the discretion to stop at level 1 and had to go to level 2.
Had there been an explanation a different explanation as to how the judge got there, but I'm not going to guess. We have a record here that those are the 3 factors that the judge relied on in denying level 1 modification.
So you're saying the nature of the qualifying offense can never be the determinative factor in not granting, well, I mean, he did grant a downward, he gave him a lower assessment, so not granting, I guess, the assessment that the petitioner is asking for.
It can't be, one's criminal history can, in a modification petition, I'm not saying at an original SOAR hearing, but at a modification petition where we're only supposed to be, mostly supposed to be looking at the significant rehabilitative steps that an individual has taken.
What's the legal support for that? I mean, you're not saying that you can't look at the criminal history, right? And the nature of the offense. So what's your legal support for saying you can look at it, but it can't be dispositive?
So the Davis case specifically said that language. It's also the purpose of 168.2 And I believe that the way that the Davis Court has interpreted both 16802 and the guidelines is to incentivize a registrant in order to induce them to rehabilitate themselves. And here,
But if I'm not, the Davis case was an appellate division decision, right?
Second Department,
Right.
yes.
And so what in the statute requires the result you're asking us for?
The statute doesn't necessarily require it, if that is specifically what your question, but the legislative intent is the fact that individuals are encouraged to rehabilitate themselves. If they do, then they can petition for these modifications. And in so doing, if we don't have this, what is the incentive to rehabilitate?
But isn't the purpose of this whole risk assessment process to determine how much of a risk the person is to the community and whether the community can feel secure in having whatever level of supervision is imposed by the assessment?
That is correct.
So how is it, I'm having trouble understanding how there's ever a time where you don't at least harken back to what it was that got us here in the first place. The offense, the specific acts contained in them, the severity. I mean, that has to be part of the determination in saying whether or not it's safe for the community to have this person under this level of supervision.
The crime requiring registration is the primary reason for your initial SORA registration, which occurred for Mr. Shader back in 1998.
Okay.
When he petitioned this court back in 2022, he was proving his rehabilitation over all those years. And in those 23 intervening years, he worked in the community. He worked as a cable installer, going into people's homes, and he never sexually reoffended. He proved by clear and convincing evidence he was not a risk. He was a very young man when he committed these offenses, the offense requiring registration and those prior acts of sexual misconduct. And the board was very clear in its recommendation that they credited every single one of the factors that was submitted in his petition. And the court, in denying his modification, just said the facts of the instant offense, the prior acts of misconduct, and the 2003 misdemeanor, which had no violence and no sexual misconduct.
Thank you.
Thank you.
May it please the court, Erin LaValle for the people of the state of New York. To briefly address jurisdiction, this case presents a mixed question of law and fact, and it's the people's position that this court does not have jurisdiction. But
Well, can we start right at the end where counsel left off? So if we're trying to determine present risk, is that fair?
yes,
So why isn't it an error of law to rely, for the court to have relied on the 2003 misdemeanor auto stripping? What does that have to do with risk of sexual offense?
because it shows the defendant's ability to put his own needs over that of society's. He was on parole for the underlying registerable offense when he committed this reoffense in
That's true of
2003.
everyone who commits a crime, and SORA is about protecting the public from sexual offense recidivists, not someone who's going to go out and commit a crime.
Correct, but those who are registered under SORA have already shown that they're able
So
to commit
jaywalking, same
sexual
thing?
offenses.
If he gets a ticket for jaywalking?
No, I don't believe that would be
Why
the same
not?
thing.
I mean, he's putting his needs of getting across the street over the vehicle and traffic law.
I think it goes towards the type of conduct, right? So he committed this offense in 2003, very shortly after he just served an
Well,
extensive
suppose he
prison-
jaywalked right after.
I don't believe that would be,
Why? Because the jaywalking doesn't really bear on whether he's going to commit a sexual offense, right?
I would agree, but in this case, he
But
was in
auto stripping
possession-
does, taking something off of a abandoned automobile?
Well, Andy was in the possession of burglar tools, which is
Well,
important to know.
what burglar tools are what? A screwdriver?
The
A
record
wrench?
isn't clear as to
The
what it
same
was.
things you might use to take a hubcap off of a car or catalytic converter or something like that?
Right, but it's important to note that the underlying conviction that he was convicted of was breaking into a woman's house, burglarizing it, and then raping her. So the fact that he has these
Did he have
tools,
does the record show he had burglar tools when he broke into her house?
it's unclear how he got in.
It doesn't show that.
Correct.
Do you agree with your adversary's reading of Davis?
I do not. In terms of Davis being the standard, I don't believe that Davis is a standard. I think that in these cases, these modification proceedings, it has to be an individualized approach that comes down to the very specific facts relevant to each offender. In Davis, different from what we have here, the defendant was found to be permanently disabled. He was unable to ambulate, he had multiple other health issues, and he showed no actual likelihood of
So if the
reoffending.
record here would have established that the defendant was permanently disabled or severely, like in Davis, would then there be a stronger argument that it was an abuse of discretion? Because he couldn't reoffend in the manner that he had in the past.
I think when an individual has something like a permanent disability, courts routinely find that that's something that highly impacts their risk of recidivism, right? If they're not physically able to commit an offense, then registration may no longer become necessary like it was for the defendant in Davis. So I think it's certainly something that the court would place great weight on, as the court in Davis placed great weight on that. But we don't have that here in this record with this defendant.
So what do we make of the fact that the court's order here is under 168D instead of 168O?
I'm sorry, I believe this.
The order that's in the record that the court signed is under 168D, which is the procedure for an initial SORA registration risk level?
I believe that might have been a clerical error, because the analysis at the SORA modification proceeding, the court was aware that they were doing a modification proceeding, and that they were modifying the initial risk offense, modifying his registration level from what it was originally. The court seemed to
And
be
you think it's clear from the transcript that the court used the right standard?
I do, because the standard as laid out in.
There are different standards, right? D and O, I'm sorry.
Right, yes, yes. So it is a different standard than an initial proceeding, and I think that is clear because the court referenced the initial registration level in introducing the hearing. So the court did reference back to, the original conviction, the original registration level, and then what they were doing.
Why
on
does
that
that
day.
assure us that the court understood the difference between the two standards? That is, what you told me certainly convinces me the court understood that he was a level 3 because of a prior determination, but I'm not sure it convinces me that the court perceived the difference between the D and O.
Because the court noted that it was the defendant who had the burden to show by clear and convincing evidence that there was.
That would be the same with the downward modification, which is the box the court checked on the form.
Right. That would be the same for a downward modification, but that would have to come after the original,
No, I mean,
the presumptive level. So,
right, in an original SORA determination.
correct.
Right, and that's the form the court used and the way the order reads.
Correct. I do believe that was just a clerical error at this point. Because the court did say, in reviewing the defendant's petition, the court did say that they took a lot of time to review the materials, to go through each of the factors laid out by the defendant in support of his petition. I think that the court did not only rely on the seriousness of the conviction, the history of offenses, or the violation. The court weighed that.
So maybe you can answer her question. What else can he do? Maybe your answer is nothing, I don't know. What else can he do?
I think the misconception is that counsel believes that there's supposed to be this meaningful path to be removed from the registry, and I don't believe that that was ever the purpose of SORA.
So then your answer is nothing?
I don't think that's the answer either. I think that
Okay, so
circumstances can.
what can he do?
Well, for example, he could apply for a petition under 168O sub 1, which is to petition for complete relief from his duty to register. That's something that's become newly available for him because the court chose to modify him from a level 3 to a level 2. This provision is only
When would that
applicable-
become available?
Under 16801, it's only pertains to level 2 sex offenders without any designation. If that is your category of registration, then after 30 years from your initial registration level, you can petition for complete relief of
So
your
let's say he doesn't want to
registerability.
wait that long. What else would make this the kind of petition that if a judge didn't reduce it to level 1, it would effectively be an abuse of discretion?
So just to note that this relief would be available to him in 2028. But also, he could continue applying for modification. He can apply to have his risk assessment.
And then what would he do?
There-
What is he left to show, I guess is the question.
There could be other factors that could contribute to his petition. For example, like the defendant in Davis showed he had some serious health factors that were going on. So that, that could be something, I know that's something that courts have placed a lot of weight on. So that could be something, but
Yeah, but to sort of say he should become disabled to become a level 1 seems a little perverse, I guess. Let me try Judge Rivera's question in a different way. Is there a point at which somebody could have a record that was, that would render a judge's decision not to reduce somebody from 3 to 1 an abuse of discretion?
No. I believe that it's a discretionary choice, it's a discretionary decision based on the individual. There's some circumstances where someone might be fully rehabilitated to the point where registration is no longer necessary, but on the other hand, there are some offenses that require lifetime registration. For example, any designated offender, if you have a certain designation, you're required to be on the SORA registry for life. There is no way around that.
Just to be clear, your position is if we're talking about a reduction from 3 to 1, there could never be any case that we could hear in which we could say this is an abuse of discretion.
For a
refuse
court
for a
not to
court
grant from
time-
a 3 to a
right.
1. Correct.
Okay. Just
What if
wanted to
they're
be clear.
quadriplegic?
In terms of using that as a factor to consider their
Yes.
risk of reoffense?
Yes.
Courts have found
I'm
that
asking you,
lowers.
I'm asking you under your analysis of the statute.
It's such an individualized approach, I don't believe I can answer that question. I
So
think
then
that's
your
something-
position is that it could be possible.
It could be possible.
It could be, well, no, you didn't let me finish that sentence. It could be possible that someone who becomes a quadriplegic applies to be designated level 1, be off the registry, it's been enough years to be off the registry, and a judge could still decide to keep them on as, let's just say, a level 2 for this moment. And in your view, that would not, we could never conclude that's an abuse of discretion.
I think there are other factors the court needs to consider. For example, in that instance, it depends on, going back to what his crime of conviction was. If he was an offender who was a violent offender, who was committing
I
physical acts.
thought you would have gone with the yes on that, but okay.
But, for example, if he.
Kind of an
if
easy
he-
case, is it not? He's
You should've-
physically unable. That's where
Right.
you started, that there are these cases where courts have recognized you're physically unable to commit, well, you said offense, I would have said
Right.
sexual offense, but let's go with it. Offense, that would be that category. So I'm a little bit surprised that in my example, you wouldn't say, yes, Judge, that's exactly the one. The whole one of those that will come up in the next 50 years fits that category.
I think if that offender had, a long history of child pornography offenses, that might be something
Okay.
that the court could consider in the risk of reoffense as to whether or not his condition would affect his ability to reoffend. So for this particular,
But if, in my example, it is someone who cannot physically
Cannot
commit an
physically-
offense. Correct.
then yes.
I take your
Yes.
point about the child pornography. Okay.
See, my light is on.
Thank you.
Thank you.
Judges, I'd like to address something of the elephant in this case, which is Mr. Shader is not subject to automatic lifetime registration. He does not have a sexually violent offender designation. I submit that if he had that designation, we might not be here today because he demonstrated by such clear and convincing evidence that he is a low risk of reoffense. And had he been subject to lifetime registration, The court might have been more inclined to give him a level 1
So
registration
how
level.
would you factor in the crimes that led to the designation?
They were already factored into the original level 3.
But let's say level 3 is the highest, right?
Yes.
So let's say you have 15 horrific sex crimes, and the most I can do for you, they can give you a level 3. And now I have one person who barely gets over the line to a level 3. We start at the same place on a downward departure because they're a level 3. And we can't consider the 15 heinous sex crimes this person had in determining whether or not they remain a danger to the community. We have to treat those two people the same. They put the same rehabilitative proof in, and we treat them the same because they start as 3s and we're not looking behind the 3.
As counsel pointed out, every case is an individualized assessment.
So the
However,
rule
but
isn't
in
you
your,
can't look at it.
there is never a case where you cannot look at the original.
Okay.
But I submit that this court should adopt the standard which was put forth in Davis, which is that an individual's criminal history, specifically the crime involving registration, should not be the thing that keeps them from having a path to level
No
1.
matter how heinous or how much it appears to indicate some risk of recidivism.
Not when
You're
there's,
looking for a, I'm trying to understand why you're looking for a bright line rule there,
because
as opposed to saying it generally shouldn't, or it should be the rare case, or something like that.
what Davis tells us is that if we don't have
We're
a
not
path-
bound by Davis, so
No,
I'm just
no,
asking
I
from
think-
first principles, why
No.
why would we adopt a bright line rule as opposed to saying that it should be the rare case or something along those lines?
I'm not sure if it's a bright line rule, but I think it's because there needs to be a path, whether every individual can get to level 1, but there needs to be a path for everybody to
But
know
why
that
isn't
they
the
can get
path
there.
through level 2? Like
Excuse
you
me?
have a path. You got to level 2. Now you have a path to level 1.
But what is the path to
But
level 1?
you want a path from 3 to 1. You can come in and ask for another modification.
We could, but what I
But you're
submit is
saying
what
they
else
should-
is there?
There's nothing else. The time, other events, nothing will matter. You're conceding right now on this record, whatever he does in the future, he will never make an argument to get to a level 1 modification from a level 2.
I don't know what another judge may say, but statistically speaking, the forensic evaluation's not going to change. His forensic evaluation said he's already at that point where he's been out in the community for enough time where he's at that lowest level, that his static and dynamic risk factors, his static factors are not going to change, but he's done all of those things in which he can lower his risk
And
of
it isn't the
reoffense.
fact that they could take into consideration that you've now been on a level 2 designation with the level 2 requirements for X amount of time. I'm a judge, that gives me more comfort that I can now place you on a level 1. That you shouldn't be able to do.
I think that may be appropriate in some cases, but perhaps where
So
it's
that's
somebody
your
who has
path
not.
to level 1. Why isn't that a path to level 1?
Perhaps
Show
that's-
that you don't reoffend on a level 2 with less stringent conditions, and then we can talk about level 1. Why can't a judge do that?
Perhaps it may be more appropriate for somebody who has not been on the registry for as lengthy a time as Mr. Shader has. Mr. Shader has been on the registry since 1998. It's a very significant period of time in which he
But
was,
they were very significant crimes. They were relatively minor misdemeanor arrests after that. And you're now a level 2. Show me what you can do on level 2.
and I just do want to say, though, that it was one misdemeanor arrest with 2 charges, and then as my opposition did note, there was no facts indicating that there was any indication that it had any sort of bearing on his risk of recidivism, of sexual recidivism, and SORA needs to be about his risk of recidivism. Otherwise, it's becoming punitive if it's not.
Just, if I may, just to clarify, between risk level 1 and 2, I know in his case he'll be off the registry, given the number of years, but let's say that wasn't the case. What is he going to be doing differently to comply with 1 and 2, between those two?
For him specifically,
Yes.
it doesn't change his necessarily reporting requirements. The biggest difference is whether you're pictured on the internet registry.
You
So
3 and
it's-
2, that is. That's a difference between 3 and 2, or
No.
2 and 1.
Between 2 and 1. Between 2 and 3, it's a very big difference in
Right.
terms of reporting requirements.
So then it boils down to just more time on the registry.
I'm sorry?
In terms of, well, if he's going to come back, it's just more time on the registry with, I assume, having committed no other offense.
Assuming, but that's not going to change his risk of reoffense. The facts are the facts of this case.
It won't lower, it would not allow a judge to have certain comfort that the risk is probably lower if he's now gone yet another 10 years under a registry regime?
But I think this is why, in my rebuttal, I wanted to suggest to this court that the elephant in this case is the prosecution's going to suggest again, this is about getting him removed from the registry, and they don't want to see that happen. And this is not a 168.01 petition. This is a 168.02 petition about his risk level, not about whether he's going to be removed from the
understand.
registry. That's by operation of law. This is a 168.02 petition about what is Mr. Shader's risk of reoffense, and he has proved by clear and convincing evidence that he is a low risk.
Thank you.
Thank you so much.